Good morning and welcome to the Government Information Center. I'm your host, Tuafisha Fumbabi, and I'm delighted today to stir a conversation of national impact and which help to communicate the literacy of government initiatives. The Labour Commission serves as a critical bridge between workers and employers, where disputes often arise. But it's much more than that. And today, I'm delighted for an in-depth understanding of the functions and where it's most impactful. I am joined by officials from the Ministry of Labour, Industrial Relations and Employment. To that end, I would like to welcome Mrs. Kiliki Sikrege, the Labour Commissioner, Ms. Martha Nikela, Senior Administrative Officer, and Ms. Betty Amunyela. Thank you very much for joining us and welcome.
Thank you. Thanks very much.
Okay, I would like to dive right into our conversation with Mr. Sikrege, just to find out the functions of the Labour Commission. When did they come into being?
Okay, since November 2008, and rather to say with the promulgation of the Act number 11 of 2007, the Office of the Labour Commissioner was established. And then since November 2008, the Office of the Labour Commissioner serves as an alternative dispute resolution, which was established to expedite the resolution of labour disputes. Prior to its establishment, labour matters were held or were dealt with by the then District Labour Court. And with that, it's only they could have afford the services of that institution. However, with the introduction of the Office of the Labour Commissioner and the alternative dispute resolution, the marginalized and the disenfranchised communities have no access to social justice, and they have access to justice. So the functions of the Office of the Labour Commissioners are that the Labour Commissioner register labour disputes that are referred by employees, trade unions, employers, and employers' organizations. The Labour Commissioner attempts to resolve such disputes through conciliation and arbitration processes. And the Labour Commissioner also register trade unions and employers' organizations. And then the trade unions represent the interests of the workers, while the employers' organizations represent the interest of the employers. The Office of the Labour Commissioner also, if required, provides training to social partners, and that is to trade unions and employers' organizations, so that at least they have got a better understanding of what the provisions of the Labour Act, so that they will be able to deal with the labour disputes or to assist their members, so as to advance the interest of their members. The Office of the Labour Commissioner also compile reports and statistics, so that the statistics will then help the lawmakers to be able to make informed decisions when they are crafting the laws and so on. And when you look at, or when you see reports about the retrenchment, the statistic pertaining to retrenchment or to strikes in the country, that information will be coming from our office. We provide that information because we record such information. And then the Office of the Labor Commissioner operates as an administrative tribunal, and then all the disputes are dealt with through conciliation and arbitration. Okay.
Very, very interesting indeed in terms of what your office is doing. I think it's very commendable. And I am sure that the Namibian nation is intrigued to learn of all your functions, because sometimes we just feel, or the public sometimes feel, that what are they actually doing? But just listening to what you're saying is that your office is quite inundated with a lot of functions, relevant functions that really need to be applauded. Thank you very much for that.
Okay.
Ms. Amunyela, what exactly is a dispute in terms of the Labour Act?
All right. A dispute that is referred to the Office of the Labour Commissioner, we have to understand first why the existence of a dispute. And the dispute is defined in the Labour Act as a disagreement between employees or their trade unions on one hand, and employers and employers' organizations on the other hand. But such dispute or disagreement must be in relation to a labor matter, right? So, meaning that the scope or the jurisdiction of the Office of the Labour Commissioner is solely to resolve disputes emanating from labor-related issues, and that also means that we don't deal with disputes that, for example, emanate from criminal activities. We don't deal with disputes that involve domestic issues, or we don't deal with disputes that are coming out as a result of damages from a civil claim. So it's important to note that there should be an existence of a disagreement first, because you can't just, when there's an obligation on an employer to perform, you can't just come straight at our office when there's no disagreement. There should first be a disagreement in order for you to establish that it's a dispute. Yes.
Do you get a lot of cases where somebody just comes to your office because they feel that they have a case?
Yes. When I also mentioned that we don't deal with criminal matters, some employees feel like just because a certain incident, for example, happened at the workplace, maybe an employee was beaten up by a colleague or a client, and they are in the opinion that it took place at the workplace, they feel like they should refer such dispute. But we only deal with, it should come from a labor-related issue or employment-related issue. So there are certain disputes referred where employees or employers feel like they have a case, but that can only come, or the outcome thereof can only emanate through the process.
Perfect, understood.
Okay, in addition to that,
yes.
To say there is a disagreement, like for example, if an employee has been dismissed from employment, there are companies that make provision for such employee to appeal. So the fact that you received your dismissal letter does not give you a right to refer a dispute to the Labour Commissioner. You first have to exhaust the internal procedures. You have to appeal. And then once you have appealed and the outcome is not in your favor, then you can say, yes, the dispute, there is a dispute, and then you can refer it to the Labour Commissioner. If you approach the Office of the Labour Commissioner without exhausting internal processes, then we will regard it as a dispute that is prematurely referred, because a dispute did not
go through the proper channels.
It did not exist then. Yeah.
Thank you very much for that explanation. It makes a lot of sense and it's well understood. Ms. Nikela, how does one refer a case to the Labour Commissioner?
Thank you for the question. One can refer a case to the Office of the Labour Commissioner. Any party that is aggrieved or unhappy with the any act that happened to the employment places can approach the Office of the Labor Commissioner or the Ministry of Labor in the town or place where the person found him or herself. The referring of dispute to conciliation or arbitration, client or applicants or parties can obtain referral form at the Office of the Labor Commissioner, which are to be completed by the referring party, him or herself. And this application form or referral forms, we are expecting them to be completed properly and correctly and should be signed by the applicant or a co-colleague if there are more than one. However, it's important to mention that when completing the form LC21, which is a referral document, a summary of dispute should be attached to this form, and these two forms are to be made copy, which copies are to be saved to the respondent. When the copies are saved to the respondent, the applicant then have to go to the police to satisfy correct that all these forms were duly received to the respondent in the manner in which the person have saved the other party. It's also important to, important to mention that it's very important for a referring party to make sure that indeed the other party in dispute has been served. And we are to satisfy as the Office of the Labor Commissioner that yes, indeed, the other party was served upon bringing those referral documents to us. There is a form also that is attached to the referral document, which is called LG36. That is a proof of service of document on how you serve the other party with the referring document, which is now your summary of dispute, and the LC21, which is a form that is very, very important, because that is the form that is telling us the nature of dispute that you have, the time on which the dispute arose, and it's also important for us to inform the nation that the summary of dispute is very, very important, that it should highlight where the person have worked, the town. An example to say, when you summarize, you should tell us in which town that you work, in order for an office to establish the jurisdiction, whether we have it or not, to hear your case.
Absolutely. Commissioner, looking at the cases that Ms. Nikela was talking about, who has that responsibility to refer those cases to the Labor Commission?
Okay, thanks very much for the question. Okay, I would like first to emphasize on the signing of the documents,
Yes.
especially the referral documents. The parties or the persons that are allowed to sign such documents are those that are having the right to do so in terms of the Labor Act. My colleague has indicated earlier, the applicant himself or herself, a co-worker, an official of a trade union, or an office bearer of a trade union may sign such documents. And in the event where parties are more than one, then one party has to authorize or to give a mandate in writing to the other person to sign on their behalf. And we sometimes encounter challenges whereby, for example, a labor consultant or a legal practitioner or any other person has signed such documents, but that is not the right way to do so. So definitely the matter or the referral will be rejected or referred back because it did not comply with Rule 5 of the rules relating to the conduct of conciliation and arbitration. Okay, who may refer a dispute to the Labor Commissioner? It can be either an employee or a trade union referring a dispute on behalf of their members. It can be an employer or an employer organization referring a dispute on behalf of its member. And then the issue of signing and so on, because you find sometimes there is a dispute of interest, and then it's the trade union that may refer a dispute on behalf of its members.
Commissioner, just hearing the information, the load of information that we are talking about today, what platforms does the ministry have to essentially educate the Namibian nation? Because I feel that this information that we are sharing is quite important, and most of the people are employees, and they don't always know where to find this information. So I'm just thinking out loud to say, what educational initiatives is the ministry really looking at to educate the Namibian nation?
Okay, this platform is one of them.
Absolutely.
Where we are today, and the audience, we believe they are following, so that tomorrow they will be able to do the right thing. We've got also road shows that are arranged by the ministry, and the Office of the Labour Commission in particular also partakes in those road shows. We have got now even the Windhoek Showground, or the agricultural show. We will be there, and we'll be explaining, we'll be having our forms, we will be having pamphlets that will be, giving out to the
Public.
to our potential customers, so that they understand and they know what is expected of them when referring a case. And we are also planning to have to appear on our national radios, so that we disseminate the information. And our people on the ground are there. The administrative officers, they are there to explain how parties should complete the forms and so on. And yeah.
Thank you very much. That is very informative. And there you go, Namibia. There is platforms, opportunities for you to hear this information. So, for example, the commissioner mentioned, visit them at the Windhoek Showgrounds, starting, I believe, on Friday, where you can find out all about the activities of the ministry, and you will be well informed. Ms. Amanyela, just a quick one with regards to, just take us through what type of disputes does the Labour Commissioner deal with?
All right. Thank you very much for that question. So Ms. Nikela properly explained that the referral of dispute, the Office of the Labour Commissioner only deals with disputes of right and disputes of interest. So what is a dispute of right? So if I generally have to explain what a right is an entitlement by law that an employee or employer or their trade union or an employee, their trade union, or an employer or the Employers Federation has, which is provided for, protected for by the law. So, for example, we usually hear phrases from people saying that I have a right to a fair trial, I have a right to freedom of association, or I have a right to not be discriminated against. Those phrases are usually used because such protections are coming from the Namibian Constitution, right? So when there's an infringement of that right, the same Constitution also entitles aggrieved persons to seek redress. So coming back now to a dispute of right or a right in terms of labor matters, such right must emanate either from a collective agreement, from the Labor Act, or from the employment contract. All right? So when there's an infringement of that right, parties may seek redress at this tribunal, the Office of the Labour Commissioner, for arbitration. That is, in a nutshell, a dispute of right. Going back, on the other hand, a dispute of interest, it's a dispute concerning a proposal for a new or changed employment condition, right? So it's not a dispute concerning a right that you already have. So or in other words, I may call it, it's a dispute of want, or a nice have on top of something that you already have, which is contained in your employment contract or collective agreement. So it's not a dispute that is entitled by in terms of the employment contract. So that's in a nutshell what the dispute of interest is.
Okay, perfect. Thank you so much for explaining the differences. That was really going to be my next question. I just wanted to understand, so what are some of the challenges that you experience regarding those two rights?
The challenges
Yes, that you've experienced, that you've seen, that you could just slightly just highlight some for us.
All right, when it comes to this, I don't, maybe the commissioner can come in when it comes to the challenges.
Okay,
Yes.
Commissioner?
Okay. The challenges comes in when a party that is referring a case does not know the difference between the two
Okay.
disputes. And you may find that they are ticking where the dispute of interest is, but they are actually referring a dispute of right.
Okay.
And sometimes they come claiming that I want this, but they are not entitled to it. It is actually something that they were supposed to negotiate over, and then once they have agreed, then it becomes a right to an employee. And then once now such a right is violated, there is a breach of such a right, then they can now refer a dispute of right.
Okay.
Yes.
Understood. Ms. Nikela?
I just wanted to add also.
Sure.
Yes. So when it comes to a dispute of interest, because like I said, it's an interest that an employee has, which they don't already have, the parties involved usually resort to negotiations. So once those negotiations fail and an agreement is not reached, the parties that are involved, they usually resort to a power play. So that power play, in order to achieve that interest or want, from the employee side, it then results into a strike, or from the employer's side, it would then result into a lockout.
Thank you so much for explaining those differences and obviously the challenges, because it's something that I saw when you just look at the media reports. Employees usually down tools, especially in the construction or housing sectors, and sometimes they complain about unfair labor practices, or they simply just don't understand fully what exactly are they like downing tools for, or what is the strike really about. Thank you so much for explaining that for me. And then Ms. Nikela, just what happens after a case is referred to the Labour Commission?
Thank you once again. When a case is referred to the Labour Commissioner, the Office of the Labour Commissioner have a system in place where all cases, or we call them rather referral at the early referring stage, that all referrals that are referred to the Office of the Labour Commissioner are recorded on a daily basis. There are staff members that are dedicated to do that on daily basis. And after those cases are registered, they are then screened. They are screened for quality assurance so that we make sure that cases that are to be conciliated or to be arbitrated are those that have passed the test. Once they now have passed the test, they are then handed over to the Labour Commissioner, because the Labour Commissioner then is the one that designates a conciliator or an arbitrator to conciliate or to arbitrate on the case. However, cases that have not passed the test, they are referred back, and the parties, specifically the referring party, is being informed to come and make correction where possible. For those that maybe are no longer able to be corrected because maybe they are referred out of time, those that are prescribed, again, the applicant who's the referring party is informed of the progress of the case, that say, no, this is what is happening, and the person have to come in so that we explain properly that your case is referred, but then is out of time, or the office can write a letter that is explaining properly as when was this case supposed to be referred. The time period is very, very important, that the person should know when and how the case should be referred. And it's also important just to note that the recording of cases is done for statistic purposes, and it's important for this office that once we have this record, those that are following up on their cases, if they were not informed on time, maybe on the progress of their cases, the first thing we do, we go to our registry to see that, yes, indeed, the follow-up that you are doing on your case, this case was referred or it was received, and when was it received. However, when we saw that the case it was received and perhaps maybe parties were not informed, the very system where we register cases, it will talk to you to tell you how far the case is. If it was referred back, it will tell you it's referred back. If it's designated to an arbitrator, the staff members that are responsible to summon cases, they sign off. It will tell you already that it's allocated to social arbitrator. It was signed off, so the file is where. So it's very important for us to have such a registration, because it speaks to us to tell us how the movement of those cases are.
Absolutely. That is really clear and very well understood. And then, Ms. Amunyela, how are these disputes resolved?
All right. So as Ms. Nikela highlighted, that once a dispute has gone through the due process of registration and screening, and then the Labour Commissioner then designates a conciliator to conciliate over disputes of interest, and the Labour Commissioner also designates an arbitrator then to arbitrate over disputes of right. So the conciliation disputes, the disputes of interest are conciliated in terms of Section 82 of the Labour Act, while the arbitration in terms of disputes of right arbitrated in terms of Section 86 of the Labour Act.
Thank you very much for that. And then, Commissioner, lastly, and finally, I would just like to find out how long does it take to really resolve some of these cases?
Okay, before I answer that question, I would just like to emphasize to say the public must know that there are time frames within which a dispute must be referred to the Labour Commissioner. If it is a dispute of unfair dismissal, it should be referred to the Labour Commissioner within 6 months. And if it is any other dispute, it should be referred within 12 months. So if now such disputes are not referred within the prescribed time frame, we would regard that dispute that it has lapsed, and the Labour Commissioner has got no jurisdiction, has no jurisdiction to deal with a matter that was referred beyond the prescribed time frame. Okay, regarding your question, how long it takes for a dispute to be finalized, it will all depend. Some disputes are resolved immediately as they, on the day that it is set for the dispute to be heard. Some are even resolved before the date of the hearing comes, because parties, they may engage one another and decide to resolve the matter on their own. Or the parties at the conciliation, because our system is a corner system when it comes to disputes of rights. So during the conciliation phase, the parties may reach an agreement there. So it will only take 1 day for it to be resolved. Some, they take longer because of postponements, sometimes occasioned by the parties themselves. Some, they would want maybe to enlist the services of legal practitioners. Some they enlist the service of a legal practitioner, and then at a later stage, the legal practitioner withdraws, and then they will seek leave to obtain another legal practitioner. Some it's due to sickness, non-availability of witnesses. Maybe an arbitrator is also not at work that day due to sickness or due to some other equally important activities that just came up and cannot be postponed, but rather to shift the matter to an earlier date. So it will all depends on how, but the idea is that we should resolve those disputes within 30 days. But sometimes it's really something that is beyond our control.
Okay. Thank you
And
very much.
If I may also come in, we've been discussing disputes of rights and disputes of interest, but I also just wanted the public to understand, for example, what actually are the examples of disputes of rights and then the examples of the disputes of interest that can be referred. So when it comes to the disputes of rights, the common ones that are referred at our office that we deal with is, for example, a dispute of unfair dismissal, because the Labour Act now prescribes that it is unfair for an employee to be dismissed unfairly. So they may refer a dispute of unfair dismissal, or they may refer a dispute of unfair labour practices. For example, unilateral change of terms and conditions of employment. They may also refer disputes of organizational rights, such as trade unions may refer disputes for recognition, or when there's a disagreement between a trade union and an employer with regards to the recognition of an exclusive bargaining agent. So trade unions may also refer such disputes. We also have disputes such as severance pay, or when it comes to leave day payouts upon termination. So those are just your common examples of the disputes of rights. So when it comes to the disputes of interest, an example would be a wage dispute. So sometimes when economical reasons arise, such as inflation, among others, employees feel like they maybe need a wage increment, because remember, when you entered into an employment contract, certain terms and conditions were placed that you agreed upon between the employee and the employer. So on top of that, maybe as a result of now, like I explained, inflation, they maybe want a demand of a 10% increment. So they may also refer disputes of interest for wage negotiations. Another example of a dispute of interest would be maybe a benefit which they also didn't have. For example, transport allowances or other types of allowances. Or maybe when the employer wants to defer or to change an employment condition. So I just wanted to note that those are the examples of the common disputes in terms of the dispute of rights and then the disputes of interest that they can refer.
Okay, thank you very much for that. And then what are the most common ones that the employees come out and inquire about or are essentially involved in as well?
Number one, I would say it's the disputes of unfair dismissal. Yes, followed maybe by the dispute of unfair labor practices, unilateral change of terms and conditions of employment, and commonly right now, the dispute of severance pay also has really been common in our office.
Okay.
Yes.
In addition to that, there is also a dispute of non-payment of wages.
Yes.
Yes. Because you go and you perform your duty, but the employer fails to
Pay you.
reciprocate in terms of paying you the wages for the work done.
Yeah, that's not good. Is there anything else that you'd like to share with the members of the public that we might not have discussed or that you'd essentially like to share on your end?
Just maybe to say, of late we have been receiving, like calls that a party would want to see an arbitrator in the absence of the other party.
Oh,
We would really like to discourage that because we want to promote the integrity of the office, the confidentiality, the impartiality, and the fairness. So if you come now, you want to see an arbitrator like my colleague here, Ms. Betty, is an arbitrator.
Yes.
Now you have a case between yourself and Kiliki, and now you want to go and see arbitrator Betty in private without me knowing that you are going to meet with her. If I hear about it, how will I feel? I will feel that she's being biased because I wouldn't know what they have been discussing. And even if she tells me, no, he just came to ask when is the award going to be issued, when is the next date of hearing, I wouldn't believe that because I was not there. And I know that, all those sort of things may, I may think of whatever I want to think because of that conduct. So we encourage the public to say, if you want to speak to an or to convey something to an arbitrator, do it through the administrative officers, because the administrative officers at the Office of the Labour Commissioner, they play a role of a conduit between the parties and the arbitrator. So whatever you want to say it, inform the administrative officers, then the administrative officer will communicate such information to the arbitrator, and the arbitrator will provide the answer to whatever query is, so that the admin can now convey it to the parties.
perfect. Ms. Tenya, do you have anything to add? Your final words?
Yeah, just to add on what the commissioner had already said is that, so whatever correspondences that the parties wish to have with the arbitrator, it's encouraged that the correspondence should also be copied then to the other party. So whether you are sending a letter or you're sending an email, you should always CC the other party, just to uphold that impartiality and transparency of the arbitrator.
Thank you very much. That's very true. Ms. Nikela, anything that you'd like to add?
Thank you very much. I just want to add to say we are asking our client, the clients of the Office of the Labour Commissioner and that of the Ministry of Labour in the whole country where we are represented, that it's very, very important that when they are referring their cases, we need to see the place where the person have worked. Because this takes much of our time when we are screening. We have to leave what we are doing and call one by one to find out where the person have worked. And it really takes much of our time. It's very, very important that they indicate on their summary of this dispute, and the physical address of the respondent should be very, very clearly indicated on the form LC21.
Thank you very much for that feedback and that information. And there you go, Namibia. The Labour Commission exists to ensure that you or it, as an important actor in the labour sector, that your rights as well as my rights are protected. And you too, Namibia, can be part of this discussion. Please follow us on Facebook, on the Ministry of Information and Communication Technology, and then on YouTube is MICT Namibia. We have come to the end of our discussion, and I would really like to thank my guest in studio today. This conversation or discussion was very impactful. I hope that we've all learned something from it. I certainly took a lot from it, and I wish we had, even more days to just discuss this important part of our contracts as employees and employers. And thank you so much for coming in. Your conversation and your information that you gave to the nation was indeed impactful, and I would say very, very informative. Join us again tomorrow morning for another informative discussion from me, Twafisha Fumbabi, and the team here at the GIC. It's goodbye for now.